question. So again, we're talking Unit 5, and you all know, I think it's question 2. So I'll go ahead and read it. Richard Posner wrote that the American public worries more about invasions of privacy than about summary proceedings against suspected terrorists, curtailments of the freedom of speech of the law-abiding, or the right of the media to publish government secrets. Do you agree or disagree with this statement? Why or why not? And to what extent, if any, is privacy in jeopardy today? What protection, if any, do people have from privacy violations by governments or businesses? You may begin.
Political activist John Perry Barlow once said, "Relying on the government to protect your privacy is like asking a peeping Tom to install your window blinds."
The United States government has a shocking history of public surveillance and of breaching the privacy of American citizens. This big brother state has not gone unnoticed.
Although Posner downplays the other threats like foreign or domestic terrorism when compared to the right of privacy, we believe the right to privacy is incredibly important.
We also agree with Posner's statement saying that Americans prioritize their privacy rights and should be paying more attention to them over other liberties such as curtailment of speech.
The federal government's access to private information of citizens is borderline shocking, and Americans are becoming more aware of that.
In fact, many value their privacy over issues such as national security. According to a recent Reuters poll, 3 out of 4 people would not give up their personal emails, text messages, and phone calls in order to help the U.S. fight foreign or domestic terrorism plots.
Furthermore, the survey revealed that the issue of privacy has strong support among both liberals and conservatives. It is clear that the protection of private information is on the forefront of the minds of many Americans, especially as citizens' private information is becoming more accessible.
While a person's right to expression comes down to a personal choice, everyone has at least some expectation of privacy in their lives. We believe that privacy is a first-class right, like speech and religion, and should be treated as such.
While freedom of speech is almost unilaterally protected in American law, privacy faces a much fiercer threat. The reason that controversy often surrounds the First Amendment rights is because people are much more aware that they have these rights.
Although many value their privacy, few understand its real significance and the threats that it faces.
Although there are protections put into place, this freedom has always been in jeopardy. Through the FBI, the Department of Homeland Security, and other law enforcement agencies, our government has the ability to view our personal information with ease.
For example, surveillance programs such as Bull Run and DCSNet are implemented to monitor citizens. Privacy invasion extends into the private sector as well.
The Facebook Cambridge Analytica scandal of 2018, where massive amounts of data were used for advertising purposes, is just one example of this.
With the massive boom in technology, the government and private companies have easier access to our data, and citizens must become more aware of that.
Privacy extends beyond just our personal information. Privacy rights cited by the Supreme Court include the privacy of beliefs, the privacy of one's home, and issues dealing with family, marriage, and parenthood.
Though the court has protected these specific privacy rights in cases like Roe v. Wade, that does not mean that those rights are not in constant jeopardy every day from both government and private action.
To counter this, many protections exist for our privacy rights. The Fourth Amendment states that citizens have a right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, and this right shall not be violated.
The Fourth Amendment seeks to strike a balance between society's need for order and an individual's right to privacy. In cases such as Riley v. California, the Supreme Court has protected private property as well, including cell phones, citing the need for a warrant.
Although not directly stated, inherent in the Due Process Clause of the 14th Amendment is a fundamental right to privacy. This interpretation allows for privacy to be protected in cases such as Lawrence v. Texas, where the court protected intimacy of same-sex couples under the right to privacy.
Institutions like the Federal Trade Commission also act as a protector of privacy rights by enforcing federal laws related to consumers' privacy and security. Ironically, the government is often the main protector of our right to privacy.
We believe that privacy is a first-class right, and although it is never directly stated in the Constitution, the government and private companies must recognize this.
Over time, different interpretations of the document have come about to allow for privacy to be protected among all citizens.
Regardless of opinions on other liberties, one thing that we can all agree on is that the protection of our privacy rights is important for the upholding of our democratic society.
As Gerald Levin said, the issue of privacy is not
time, Ellen?
That's time.
Okay.
So please finish your sentence and we'll move on to the other questions.
As Gerald Levin said, the issue of privacy is not for us simply as a matter of business practice. It's just fundamental to human dignity.
Thank you. We are now open for questions.
Great. Thank you so much. So you covered a lot of ground there, and there's a lot of information in this particular question about the role of privacy. So I wanted to kind of bring it into the current immediate circumstances. In the current COVID-19 environment, with the idea of contact tracing and tracking of movements, how should courts balance the public safety goals of government versus individual privacy rights?
Well, obviously, when you take a look at that, and I think looking at what Posner was trying to say is a good way to kind of see the two different sides of it. So Richard Posner kind of asserts that the court should be more pragmatic in thinking that because of a national crisis, the government should be given more power in certain times like this. So, for example, when you look at what Apple and Google are doing with contact tracing, they're saying that they have the ability to track your information and see who you've been in contact with. However, those companies have stated that they do need the consent from citizens in order to do so. So I think that's where the court is trying to come in and try and strike a balance between protecting people's privacy or protecting national security. And I think that's certainly a problem that they're going to have to face.
And I look at, we're arguing that privacy be treated like certain First Amendment rights like speech and religion. And while those are widely protected, we still have some tests in place that we can use to limit them, like the Lemon test or the Brandenburg test. So why not have specific tests for privacy in which we can limit it in specific circumstances, particularly in this current COVID-19 environment, as you described, to implement something like contact tracing?
And during this time, though, we need to remember that privacy is regardless a first-class right. And as Brent Franklin once said, one must not give up an essential liberty to purchase a little safety. And although we are in this crisis,
I think we lost a little audio there.
George, you just want to finish your thought?
Give her a second if we have her back. I think we might have a connection issue. So I'll move on to the next question, if that's okay. You mentioned in your prepared remarks that in reference to the Facebook Cambridge Analytica case, that citizens must become more aware of kind of what they're giving away. So I guess I want to ask, what happens when we've given rights to our personal data away to companies, and do we ever get those back under any circumstances? What should the law, what does the law say about that, and what should it say about that?
Well, I think a good way of thinking about this, and Tiffany C. Lee, who's a Yale Law resident as well as a privacy expert, put it pretty bluntly with the fact that the problem with a lot of these terms of service agreements with private companies is that no one actually takes the time to read them. And I think that is a pretty large problem, because I think many citizens are signing away their privacy rights without any knowledge of that. So I think when you look in terms of that, how many citizens actually know what they are giving up, I do believe that that is a problem.
And I would even add, with private companies, the Fourth Amendment applies to actions of the government. So with private companies, I think that it really needs to be taken care of by our legislator instead of our courts. And we should rely on our legislator to create laws that, straighten out these certain issues with these private companies on what data they're taking and how much they can really take from us. And I think that's been done. I think an example of that is HIPAA, maybe with healthcare records, or the GLBA with banking records.
So let me ask you about that, because you made a lot of reference to the Fourth Amendment and a First Amendment, but as Peter, you just pointed out correctly, those only limit the powers of government, not of private entities. So HIPAA, for example, no private right of action. You can't sue a healthcare provider for disclosing your records in court. Would you allow a private cause of action for privacy violations outside of healthcare if you were writing the statute?
I certainly would, because it is, with this current situation, there's so much we use so much technology that uses so much of our data. And I think personally, if I were in Congress or in our state legislature, a law which allowed that, I would certainly be okay with, because I think that people should have the ability to defend their right to privacy and their personal information.
And as of right now, there are no laws in place that state that private companies can't infringe upon your rights to privacy. But I think a problem that we're looking at, and a good way that you could argue this, is that many citizens are actually signing away their privacy rights in somewhat of a contract of adhesion. Because, for example, looking at Apple products, when you sign away and say that you would agree to their terms of service, you are signing away a lot of your privacy rights. However, not many citizens can actually negotiate the terms of that contract. And with that, I think that if you were to say that you don't agree with it, it would be pretty hard for you to live in a society today without an iPhone. So I think a lot of people have to give up those rights in order to do that. So I think that it is up to our lawmakers to decide that this is a problem and that in some way this needs to be fixed. So although there isn't any law in place right now, I wouldn't be against a law being made to protect those rights.
Great. Thank you all very much. I will either give you my
Fantastic.
virtual applause or
There we go. Yeah.
come remotely. Excellent job. Thank you all. Let's see, a little bit of feedback from us. First of all, this topic there's so many levels to this. And I thought you did a really nice job talking about, what has the court said about privacy? And that goes to abortion rights, health decisions, and all those other things too that aren't necessarily, privacy is a big thing and a big spectrum. And you also did a really good job. I teach a class at IU, and one of the big themes that I always bring up is technology as it relates to law and evolving issues of public policy. And certainly in privacy, this is a huge issue. There are things that can happen, frankly, this year that couldn't happen a couple years ago, or even, a shorter period of time. It's happening so fast. So the ability of technology to interrupt privacy in the name of something good, like, potentially helping people stay healthy or stopping criminal acts. But it's a tension between those rights. And I think you did a really nice job of talking about that from a couple different perspectives. And the idea of the private versus the government action, that's another big, huge issue. And I thought you did a nice job of talking about, look, it's not necessarily the Constitution that's going to protect us from private encroachment. It's legislation and things like that. And we didn't have a chance to get too much deeper, but where does the United States play, where are we in that spectrum versus other countries? And we have a different system of protections than other countries, so it's going to look different. But I think you did a great job. I'm so very pleased to have met you this morning and really proud of you for making this work, and you did an awesome job. Caitlin, I'll turn over to you.
Yeah, I echo those sentiments. I actually really liked, so sometimes the kind of knee-jerk reaction for We the People is to stick very tightly to kind of the constitutional principles, and you guys covered what is covered in the, the We the People materials expertly, kind of in the middle of your presentation where you're like, yeah, we know this, but Posner's talking about present day issues. So we're going to throw at you the FTC, the Cambridge Analytica case, and all of these kind of more modern applications of the foundational principles. You did that very, very well. And that kind of teed up what was, I think, a really interesting conversation that has practical applications to what we're all dealing with literally right now. Danny, your note quite towards the end of our Q&A there about contracts of adhesion. Obviously, I work in a company where we have a privacy policy in terms of service that we send out to customers, and I think your point about Apple and needing a phone to participate in society is really interesting. What I would have loved to debate with you is whether all online services should be treated as contracts of adhesion, or, do I really need to be on TikTok? Or can I actually read that contract and make a determination of whether I want to give up my privacy rights to those companies? So just throwing that back, and it's really just a testament to how well you guys knew the material, not just what we would expect you to know, but also that you all did your research and went way outside and brought it into present day. So excellent job.
Thank you.
So I mean, that's exactly it. I was thinking as I was listening to you, wow, if this is an example of how the teams are going to be, we're in for sort of quite a morning, because this was really you really on a high level. I love the way you started. That is a great quote, the Peeping Tom quote. It's really apropos of all of this. And it's interesting, Caitlin mentioned the contract of adhesion. I would have loved some more time to get into that, because it is exactly right. Everybody just sort of clicks right away, accepts. And won't we all be surprised when we find out that we've all agreed to give up our firstborn child, and down in the, the fine print at the bottom. Look, the best example of a great presentation is, I couldn't believe that we had run out of time. I had, so many things I wanted to explore with you. So, Mr. Hanson, Mr. Trenkel, what a fantastic job you've done. And please extend to your parents our gratitude and our appreciation for all that they've undoubtedly done to keep you sane and keep everyone from killing each other during this, this time of forced quarantine. So good luck.
Thank you all very much.
Thank you very much.